welcome back to our YouTube channel. I've got a great topic for you today. I had a high school teacher who subscribes to our YouTube channel ask me, Mike, could you think you could do a video about how to run a successful mock trial? Because in a lot of high schools and universities too, they do mock trials. So I'm just going to give an overview of how I think it should be set up. So first of all, I think you want to select an interesting topic. For example, someone charged with murder. You're going to want to have a fact pattern with witness statements typed out for the witnesses and select witnesses from your students, for example. You're going to have a prosecution team of, say, 1 to 2 people and a defense team. And you need to follow the structure of a trial, and I'm going to kind of break it down as well. What makes it even more exciting is if you have a jury of 12 students, for example, and in a lot of cases, some judges might even volunteer their time to have a real judge preside with objections and make rulings, etc. And I always suggest as well, if there's some lawyers in your community or experienced criminal lawyers, maybe they can actually coach the teams and show them about trial advocacy and whatnot. So the Crown team, once they have all the fact patterns and their witness statements, and by the way, you want to probably also give them a little bit about the law of murder, maybe give them a case or written type sheets about setting out first degree, second degree murder, manslaughter, these different options for the Crown. So the Crown's, one of the students will start with an opening statement to the court, to the judge. And in that opening statement, they're going to review their anticipated evidence in chronological order, trying to paint a compelling version of events in a storytelling way so that the jurors or the judge understands what's about to unfold. That's the purpose of an opening statement. The Crown then starts calling their witnesses, and that's called examination chief. So they might call, for example, a forensic police officer. Open-ended questions, and it has to be, you're allowed to, first of all, introduce the witness name, what they do for a living, etc. But from then on, it has to be who, where, what, why type questions. You can't suggest answers, and that's called examination in chief. So, for example, officer, I want to direct your attention to April 12th, 1972. I understand you attended a particular location. What did you first see when you arrived? And the short, open-ended questions, who, what, where, when, why, you're allowed to direct them to a subject area, but you can't suggest the answer. That's called examination in chief. So after that, one of the defense team is allowed to cross-examine. And in cross-examination, you're trying to create a reasonable doubt. You're trying to weaken the person's credibility, meaning whether they're a believable witness or whether they're reliable. Now, a truthful witness might not be reliable. Reliability means that they're not accurate in their testimony. And these are cleverly structured bit-by-bit questions where you're doing questions in this manner. It's called cross-exam, leading questions. Officer, when you were at the scene, you agree with me that the lighting was not good. Or, officer, the lighting was not good when you arrived. You see how you're suggesting the answer. And each question needs to be structured in this manner. And your questions should be kind of structured so that they give yes or no answers, kind of leading the person down the garden path in a clever way. So that's called cross-examination. After that, if the Crown or the judge rules actually that a question that the Crown didn't anticipate or could not have anticipated, they're allowed to re-examine the witness only on that point. Or if something needs clarification that arose, you're allowed to re-examination. So re-examination questions are fairly limited. So the Crown proceeds in that fashion through all their witnesses in the same structure. Examination in chief by the Crown, cross-examination by defense counsel, followed by re-examination if appropriate, okay? If appropriate, because not all cases require a re-examination. The Crown completely finishes their case. At that point, then, one of the students then stands up for the defense and is allowed to give an opening statement about evidence that they want to or anticipate they call it. And defense doesn't have to call any evidence in a criminal case. The burden of proof is on the Crown. The accused has the right to remain silent. But depending on the case, the defense may want to call one or more witnesses, including their client. But the client has a right to remain silent. That's a charter right. You don't have to call that witness. And in fact, if the defense perceives there's already a reasonable doubt, they may not want to call that witness, their client. So every case is different. Same structure. Defense examines their witness in chief, open-ended, non-leading questions, who, what, where, when, why, directing them to the topic area chronologically going through the events to tell a compelling story bit by bit by bit, okay? It's just not like we're having a conversation here. They have to take their time and walk the witness for it beautifully to tell that narrative so that the jury is, so it's compelling and a clear, vivid storytelling manner. So the Crown then cross-examines with a view to showing that witness is not credible, meaning they're not believable in their oath, or not reliable. Maybe they're telling the truth, but they're just not accurate. That's what liability means. And again, re-examination to clarify unanticipated areas that arose or to clarify an answer that was given. And in re-examination, by the way, you have to ask open-ended questions as who, what. You can direct their attention to the clarification area and ask them, please clarify that issue, for example. Proceeds that way, and what happens then at the end of the Crown case, the defense counsel will stand up and tell his or her honor, your honor, that completes the evidence for the defense. Now, what happens then? So if the defense called evidence, then the defense must go first in their closing arguments to the judge or jury. And it's exciting if there's 12 students jury. I love that. I've seen cases like that where there's an actual presiding real judge who knows the laws of evidence, and it's great. So then that defense counsel will then, argue reasonable doubt. They'll talk about the key points from each witness that raise a reasonable doubt. And I like to talk about reasonable doubts too. I mean, the way I structure my closing arguments, I will argue that point A, B, C, D raises a reasonable doubt. They may want to talk a little bit about the law, how the law applies to the facts, and suggest to the court submit, in my respectful submission, that there's reasonable doubts on these areas, Your Honor, and you have to go through that in a compelling, persuasive manner to review it. And you don't sit there reviewing all the evidence. You don't include all the evidence. You select the key points that you suggest raise a reasonable doubt. Conversely, then, the Crown will go second if the defense called evidence on the closing submissions, and their job, of course, is to point to those areas of evidence that prove the case beyond a reasonable doubt. The burden's always on the Crown in these type of cases. If the accused testifies, there's a three-step process, and the defense will argue this. If you believe the evidence of the accused, let's say they testify or call evidence, you must acquit. If you're left in a reasonable doubt, step two is this is called the WD test, Supreme Court of Canada. If you're left in a reasonable doubt by the evidence of the accused, you must acquit. Even if you completely reject, this is step three, the evidence of the accused, in other words, you don't find that they're credible or believable, on the remaining evidence, has the case been proven beyond a reasonable doubt? So the defense gets a key benefit of doubt. I mean, the burden of proof, those scales of justice have to be pushed all the way down beyond a reasonable doubt. Not mathematical certainty, of course, but reasonable doubt. Those scales of justice reasonable doubt is far closer to certainty than it is to, a civil lawsuit where you just have to, who's more likely telling the truth. The defense has no burden. So then, of course, the jury, if it's a jury trial, the judge is going to charge the jury what the law and evidence is, review a bit about the facts, and then, of course, the jury can go out to deliberate. And the way that works, of course, if there's 12 jury members, in order to convict the accused, all 12 must be able to find that they're guilty beyond a reasonable doubt. Conversely, in order to acquit the accused, all 12 must find that there's not guilty. If one or more juries holds out during their deliberation, it's fun. You have them deliberate for a half hour. If one or two holds out, the jury might come back to the class, say, we can't make a decision. The judge would then exhort the jury to, try again within reason. And if there's a holdout, that's called a mistrial. So the trial ends. And in a murder case, they would have a new trial. Now, typically in Canada, on a sexual assault matter, if there's one mistrial followed by another trial, another mistrial, typically most prosecutors will give up. But I've seen jury matters tried 3 times after 2 mistrials, for example. So it's exciting for the kids, whether it's university or high school. That's the basic structure. It's very helpful if you get some good lawyers coaching all this. And maybe in a future videos, I'll consider breaking down each step to explain it a little bit more thoroughly about strategy and how to conduct examination in chiefs. But anyway, I had some positive feedback from some high school teachers and students who follow our YouTube channel, and I just thought I'd give a quick overview to hopefully make their mock trials go a little bit more successfully, and they can enjoy it, because I know it's an exciting time for the kids to do these type of cases. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.